our last lecture on Digital Personal Data Protection Act 2023, and it would be the fifth lecture on the very topic that we would like to deal in, particularly draft digital personal data protection rules 2025, and also the online privacy as provided under the Information Technology Act 2000 and the privacy rules of 2011. So until 2023, India did not have a exclusive law or framework to govern data protection. The Information Technology Act 2000 and rules notified thereunder as the reasonable security practice procedure and sensitive personal data or information rules, which are otherwise known as the privacy rules of 2011 in connection to the Information Technology Act, was exclusively governing with guidelines regarding digital personal data protection under the I.T.Act of 2000 and the Privacy Rules of 2011. To clarify, the current privacy regime is contained within the I.T.Act and the privacy rules, while the Government of India has released a draft of the rules under the Digital Personal Data Protection Act 2023. The provisions of the Act, even if it shall have not yet come into force, in particularly in regards to those rules, on January 3, 2025, the Ministry of Electronics and Information Technology released a draft of digital personal data protection rules, which are otherwise known as 2025 draft rules, inviting comments from the public and shareholders till 5th March 2025. The feedback received by the government will be taken into consideration after this date. Rules related to the establishment and functioning of the Data Protection Board of India are likely to come into effect immediately upon the publication of the rules in the official gazette. After the Digital Personal Data Protection Act is implemented, for the remaining rules, an extended period may be provided for entities to comply with, after which these rules will come into effect. The timeline has not been specified in the draft rules. So, in particular, we would like to discuss in this lecture about the draft digital personal data protection rules of 2025. So, in particularly, the draft rules in relation to the conditions of registration that a consent manager must fulfill before it seeks registration with the board as a consent manager, and prescribes certain obligations for consent managers to fulfill an ongoing basis. And the draft rules in regarding to collection and processing of data require that the note is given by a data fiduciary to the data principal, be presented and be understandable independently of any other information that has been is or may be made available by such data fiduciary, and so also the gives in clear and plain language a fair account of the details necessary to enable the data principal to give specific and informed consent for the processing of the personal data, which shall include at the minimum an itemized description of such personal data and the specified purpose of and an itemized description of the goods or services to be provided or uses to be enabled by such processing. The particular communication link for accessing the website or app or both of such data fiduciary and a description of other means, if any, using with such data principal may withdraw or consent with the is of doing so being comparable to that with which such consent was given or exercise your rights under the Digital Personal Data Protection Act 2023 and to make a complaint to the board, and that is the Data Protection Board of India as constituted under section 18 of the Act, is otherwise also known as National Data Protection Authority. So where a data principal has given consent to processing of their personal data prior to the recommendation of the commencement of the act, the data fiduciary is required to provide notice containing the above details as soon as it is reasonably practicable. The express timeline is yet to be prescribed. Also, regarding the personal data, the draft rules prescribe specific data ensure requirements for certain classes of data fiduciaries, e-commerce entities or social media intermediaries having 20 lakh registered users in India or more and online gaming intermediaries with 50 lakh registered users in India or more. Also under the draft rules, draft fiduciary is obtaining verifiable consent of a parent or from an individual identifying themselves as the lawful guardian of a person with disabilities are required to verify that the person is the child's parent or person with disabilities legal guardian, and that the parent or guardian is identifiable. And for a child, the data fiduciary must verify that the parent is an adult by using reliable identity details or a virtual token mapped to such details. These obligations related to children's data may be exempted by the government under certain circumstances for prescribed purposes, class of data fiduciaries, and for certain prescribed ages. Further detail in the section on exemptions And so also the draft rules prescribe that the obligation to obtain verifiable consent of a parent or guardian and to not undertake tracking or behavioral monitoring or targeted advertising at children does not apply to the processing of the data of a child. Why? For certain prescribed purpose, clinical establishment, mental health establishment, healthcare professionals, allied healthcare professional educational institutions, an individual in whose care as infants and children in a crèche or child day care centers are entrusted and persons engaged by an educational institution, crèche or child care center for transport of children enrolled with such institution, crèche or center, and generally to all data fiduciaries where the purposes of processing is for inter alia creating a user account for communicating by email for ensuring information likely to cause any detrimental effect on the well-being of a child is not accessible to them for confirmation that the data principal is not a child, etc. With respect to the processing of an employee's personal data, the Digital Personal Data Protection Act considers it as a legitimate use wherein an employer will not have to obtain express consent in order to process personal data as long as the processing is carried out for employment purposes or to protect employers from loss or liability or to provide a benefit to an employee. So also the draft rules further requires that the significant data fiduciary once in a period of 12 months from the date of being notified as an significant data fiduciary undertake a data protection impact assessment and on audit to ensure it is observing the provisions of the Digital Personal Data Protection Act. The person carrying out the data protection impact assessment and the audit is required under the draft rules of 2025 to furnish a report to the Data Protection Board of India containing significant observation in data protection impact assessment and the audit. In addition, the draft rules require that significant data fiduciaries observe due diligence in verifying that the algorithmic software deployed by it for hosting, displaying, uploading, modification, publishing, transmission, storage, updating, or sharing of personal data processed by it are not likely to pose a risk to the rights of data principals. So also, it would undertake measures to ensure that personal data specified by the central government is processed in a manner such that the personal data and the traffic data pertaining to its flow is not transferred outside India. Besides that, the draft rules require data fiduciaries and consent managers to publish on their website apps the following: the details of the means using which a data principal may take a request for the exercise of their rights and the particulars, if any, such as the username or other identifier of such a data principal, which may be required to identify her under its terms of service and the period under its grievance redressal system for responding to the grievances of data principals. Under the Digital Personal Data Protection Act, certain duties have also been assigned to data principals, which include complying with all applicable laws while exercising their rights under the Digital Personal Data Protection Act. And further, in regards to transfer of personal data, the draft rules state that the transfer of personal data by a data fiduciary, whether within or outside India, may be subject to restrictions or requirements that the central government may specify in respect of making such data available to a foreign state. And besides that, in dealing to data localization, as and aside the draft rules do require significant data fiduciaries to undertake measures to ensure that personal data specified by the central government is processed in a manner such that the personal data and the traffic data pertaining to its flow is not transferred outside India. However, there is no clarity on what types of personal data will be required to be localized at. And further, in regards to those draft rules we would like to discuss in regards to security in relation to personal data. The draft rules prescribe the minimum standards that the data fiduciary is required to adhere to. Appropriate data security measures, including security of such personal data through its encryption or making or the use of virtual tokens mapped to that personal data. Appropriate measures to control access to the computer resources used by such data fiduciary on the relevant data processor. Visibility on the accessing of such personal data through appropriate logs, monitoring and review for enabling detection of unauthorized access, its investigation and remediation to prevent recurrence, reasonable measures for continued processing in the event of confidentiality, integrity, or availability of such personal data being compromised as a result of destruction or loss of access to personal data or otherwise, including by way of data backups, and also for enabling the detection of unauthorized access, its investigation, and to prevent recurrence and continued processing in the event of such a compromise. Retain such logs and personal data for a period of 1 year unless compliance with any law for the time being in force requires otherwise. Appropriate provisions in the contract entered into between such data fiduciary and such a data processor for taking reasonable security safeguards. And finally, the appropriate technical and organizational measures to ensure effective observance of security safeguards. And also, finally, we would like to discuss some other important draft rules relating to the very provisions which, in connection to the draft digital personal rules, and those rules are pertaining to such as the I.T.Act in relation to Information Technology Act. As we found there is no regulation of cookies, behavioral, advertising, or location data. However, this may include personal data and it is advisable to obtain user content such as by using appropriate disclaimers. So, in that connection, we would like to discuss about the provisions of the Information Technology Act of 2000 and the subsequent privacy rules drafted in 2011. The Information Technology Act contains both civil and criminal penalties and offences for a variety of computer crimes under the Information Technology Act 2000 if any person introduces or causes to be introduced any computer containment like virus etc. into any computer system or computer network, they may be liable to pay damages to the affected persons as under the Information Technology Act. Computer containment is defined as any set of computer instructions that are designed to modify, destroy, record, or transmit data or programs residing within a computer system, or computer network, or by any means to obstruct the normal operation of the computer system, or computer network. Further, under the Information Technology Act, any person who fraudulently or dishonestly makes use of the electronic signature, password, or any other unique identification features of any other person may be subject to a prison term up to 3 years and a fine up to arrest 1 lakh. So, these are the very provisions that we found in regards to the Information Technology Act 2000 and those privacy rules framed in 2011. And as the very Digital Personal Data Protection Rule 2025 have been drafted in order to provide for necessary details, and as the Ministry of Electronics and Information Technology invites feedback, comments from its stakeholders on the draft rules along with the explanatory suggestions are available on Ministry's website. The submission of those feedbacks would be held in fiduciary capacity by the Ministry of Electronics and Information Technology and shall not be disclosed to anyone at any stage. A consolidated summary of the feedback comment received without attribution to stakeholder, then such rules will be published in the official gazette and the ministry invited feedback from the public on the draft bill in relation to the Digital Personal Data Protection Rules 2025 already has expired on 5th March 2025. So, in this lecture, we have completely discussed in detail with the reference to the Digital Personal Data Protection Act 2023 and those draft rules in particularly framed in 2025 by the Ministry of Electronics and Information Technology, inviting comments and suggestions from the public and from the stakeholders. And in that connection, also we have discussed what exactly online privacy means and what are the provisions relating to online privacy as provided under the Information Technology Act 2000, and especially in relation to online privacy, the privacy rules were framed in the year 2011 by the Ministry of Electronics and Information Technology of the central government or the Union government of India.